much for turning up at 9 a.m. on a Monday morning. I hope you all had a very good night last night. And we're going to kick things off, as we like to, with something intellectually rigorous, robust, and exciting. So we're going to start with a film about the report and the ECHR itself. And then after that, we are going to have two talks, one by Suella Braverman and one by Lord Frost. And then we'll have a question and answer with everyone in the audience. So with that, let's enjoy the film.
Britain. No, I mean, who really runs Britain? Where are our laws decided upon? Is it here, in Parliament? Or is it here at Downing Street? Or is it here at the Supreme Court? Or is it here, hundreds of miles away, in Strasbourg, home of the European Court of Human Rights? In that building sit 46 judges. We never voted for them. We have no power over them. I'd be surprised if anybody could name even one of them. Yet they can tell our government what to do without the British people having any say at all. So what is the European Convention on Human Rights? Where did it come from? Who started it? And why does it control what we can and cannot do in Britain? Amid the ashes of the Second World War, democracies in Western Europe, victorious but weakened, looked east in fear. Communism gripped Eastern Europe. Our leaders wanted to enshrine personal liberty to stop authoritarianism spreading across the continent. At the Congress of Europe in 1948, politicians including Winston Churchill proposed a Charter of Human Rights and a new international court to enforce it. So the Council of Europe drafted a new European Convention on Human Rights and set up the European Court of Human Rights here in Strasbourg. Britain saw it as a way to promote liberty rooted in our own legal traditions, Magna Carta, habeas corpus, and an independent judiciary. At first, it was about resolving disputes between countries. Individuals couldn't bring cases in the court unless their governments allowed it, something Britain refused to do. In 1966, Harold Wilson changed all of that. He allowed individuals the ability to challenge British laws in Strasbourg. For the first time, the European Court could interfere directly with British laws. Parliamentary sovereignty, the foundation of our democracy, began to be weakened. The court invented the living instrument doctrine, allowing it to reinterpret the convention however it wanted, well beyond its original intent. Then came 1998. The Council of Europe made the court's decisions binding on member states. It was a quiet change, but a seismic shift in our democracy. It was a power grab. The court could now override governments and parliaments without any democratic scrutiny.
This is a radical reforming government. Sometimes the revolution is a quiet revolution, but a revolution nonetheless it is.
At the same time, Tony Blair introduced the Human Rights Act, writing the convention into British law and putting Strasbourg decisions above our own. UK laws had to comply with the convention and the whims of foreign judges. Human rights laws expanded beyond all recognition. We began to see more and more absurd cases. Theresa May tried to deport the Al-Qaeda terrorist Abu Qatada, but she was blocked for years because of the convention. The result, foreign terrorists walking freely on our streets. It didn't stop there. It threw open our borders. Article 3, the protection from torture. Article 8, the right to a private life. Sounds reasonable, but judges stretched their meaning far beyond their original scope. It turned our asylum system into a farce. We couldn't deport a murderer back to Zimbabwe because of his love child, Article 8. We couldn't deport a sex offender back to Sri Lanka because it turned out that he was gay, Article 3. We couldn't deport a rapist back to Nigeria because of his life here. You get the picture. Britain has become a soft touch. Parliament passed 3 laws to stop the boats and deport illegal arrivals to Rwanda. Yet as Home Secretary, I couldn't deport a single illegal arrival to Rwanda because of the convention. And we couldn't do anything about it.
It gets worse. Why do the police seem so powerless against militant protesters? Just Stop Oil blocking roads, Extinction Rebellion halting the traffic. It's because of warped interpretations of Articles 10 and 11, the freedom of expression and assembly.
Judges here in Strasbourg ruled that it's okay to commit criminal damage in the name of human rights.
Remember the Colston statue case? BLM rioters pulled it down, but they were acquitted because their human rights mattered more than yours. As Attorney General, I was able to fix part of the problem, but only after years of legal chaos, and our lives get worse because of the convention.
Now! Move! Maybe that car! Now!
But this isn't just about protests or immigration.
This is about national security, because the convention is being used to persecute some of the bravest people who keep us safe, our soldiers. For years, here in Northern Ireland, our armed forces fought to keep the peace. Yet in 1995, the European Court of Human Rights ruled that British soldiers who thwarted a planned terror attack had violated the rights of IRA terrorists. Here in Belfast in 1972, British soldiers killed an IRA terrorist. It was the height of the Troubles and they were acting lawfully. Yet decades later, as retired veterans, those same soldiers were prosecuted for murder. One of those soldiers has been under investigation 5 times. He's been hounded through the courts and his life has been turned upside down because of Article 2 of the Convention. What's worse, in 2001, the European Court of Human Rights ruled that IRA terrorists deserved compensation. That's the same IRA that killed innocent people and devastated communities throughout our country. The truth is that under the Convention, the rights of IRA terrorists have become more important than the rights of British soldiers. How can we expect our soldiers to put their lives on the line when we can't even protect them from lawfare? The Northern Ireland Assembly here at Stormont is an integral part of our United Kingdom. It was created by the Belfast Good Friday Agreement, which has been the foundation of peace for over 2 decades. Now, the European Convention of Human Rights is mentioned in the Belfast Good Friday Agreement. Some people say that's a reason why the UK can't leave the convention. Well, they would be wrong. Over the last few decades, the Belfast Good Friday Agreement has been changed. Whether it's the Stormont House Agreement, the Hillsborough Castle Agreement, or the Windsor Framework, or many others, so many changes have been introduced into the original agreement. That's why we must rewrite the Belfast Good Friday Agreement and finally put the British people first. We do it by changing the Northern Ireland Act in Parliament. Now you might ask, why not reform the convention? Well, Tony Blair, David Cameron and Rishi Sunak all tried. They all failed. The convention cannot be reformed. We've run out of options. The truth is that we may well have left the European Parliament, but we are still governed by the European Court.
Some people say we should repeal the Human Rights Act, but remain in the convention. That solution won't work. The British people deserve honesty, because as long as we are tied to the European Court of Human Rights, the United Kingdom does not control its laws. The convention is undermining our democracy and our sovereignty. It's become something far removed from what Britain originally signed up to. Countries like New Zealand, Australia, and Canada protect their rights just fine without it. So now is the time to leave. No more foreign judges deciding against the safety of British children. No more vexatious prosecutions of our brave soldiers. No more open borders. Now, leaving won't be easy, but it's the right thing to do.
Here's how. First, we trigger Article 58, the exit clause, giving 6 months' notice to the Council of Europe. Next, we prepare our laws to take back control. We repeal the Human Rights Act and we reform judicial review to curb activist judges. We amend the Wales Act and the Scotland Act, and we change the Northern Ireland Act to rewrite the Belfast Good Friday Agreement so that laws are applied consistently throughout the United Kingdom. And we change the terms contained in our trade agreement with the EU. All of this is possible with the right political will. What about civil liberties? Well, our rights didn't start with the convention, nor will they end when we leave. The right to a fair trial goes back to Magna Carta. The right to life wasn't created by Article 2, it's been protected by the Offences Against the Persons Act 1861 and the common law. Torture has been illegal in this country since the 17th century. The Police and Criminal Evidence Act of 1984 protects us against unlawful detention. You see, the English legal system is one of the most sophisticated around the world and emulated globally. But most importantly, our laws should be made by your elected representatives who are accountable to Parliament, and Parliament must be accountable to you. That is how our country should be run. By you, for you. That is democracy.
Good morning again. So I'd like to start by saying that we at the Prosperity Institute are, of course, a non-party political think tank, but we are delighted that this paper has helped contribute to the debate, which means that there is now a consensus on the right to leave the ECHR and to restore national sovereignty. Because without national sovereignty, you cannot have national prosperity. Now, the subject of today's discussion is whether leaving the ECHR would make us a sovereign nation or a pariah state. This is often said by critics, that if we leave, we will find ourselves isolated and alone, that the ECHR is what guarantees our rights, and that we will find ourselves caught off a small island, trapped without the human rights that would protect us all. But we know that this isn't true. We've seen it in the film. For starters, we've had rights for a long, long time before this. In fact, many of the rights within the ECHR drew on the British tradition. And we have a sovereign parliament that is perfectly capable of protecting our rights if we wanted to, and making the laws that should do so. We know that leaving is not the end of the world. People said very similar things about Brexit, and nonetheless, here we are. In fact, the turn of history at the moment is very much against this sort of thing. If we look to Europe, we can see that there's a great deal of criticism of the ECHR. The Danes and the Italians recently coordinated a letter calling for the ECHR to reform itself. The ECHR has said no, they will not be doing that. We've seen politicians in countries like Germany calling for potentially leaving the ECHR themselves. So what we actually have here is an opportunity for Britain once again to lead the world, to say that laws that are outdated, that no longer work, that hinder us, that in many cases create great human rights injustices against the British people, rather than protecting their rights, should go, and they should be replaced with better laws. That, I do not think, will make us pariahs. On the contrary, I think it will make us a country that is worthy of emulation. And I think in the same way that with the Rwanda plan, when one spoke to people in Europe, a lot of them were looking and watching and seeing what we did, and they very much wanted to join in and were disappointed when we were unable to do so. I think we will see something very similar with the ECHR, where a lot of European nations will be able to use that as an opportunity to either leave themselves or to demand reform, or else they leave. So we should be proud if we lead the charge on that, and I think we're all very glad that that is now the consensus on the right. But leaving itself will not be everything. As we saw in the film, we also have to do things like repeal the Human Rights Act. We in fact have decades and decades of laws that are built up that will need to be pruned, removed in some cases, amended, altered, and we will have a great psychological shift because the ECHR is very much a continental law model, and what we will have to do is return to the common law and to a common law way of thinking and to encourage our parliamentarians to do so as well. This will actually be a sort of great restoration, both spiritually and legally, for the country, and that will be a wide-ranging project that will probably last a generation. But again, we can see the example of Brexit. We create those freedoms, and then we have the freedom to succeed or to fail, but we do have that freedom. And I, for one, believe in the British people, and I believe that we will be able to take advantage of those freedoms and redevelop what made us great before, what gave us prosperity, what made us the leading country, as we sit here in Manchester, home of the Industrial Revolution that changed the world more than any single thing, that brought more prosperity than any single thing in human history. That we emerged from a Malthusian world where people starved every year to one in which we have now so much wealth and so much around us, but the biggest difficulty is that people get too fat. That's a better problem to have. And thankfully capitalism provides there, because the Danes have given us Ozempic. And so I'd now like to introduce our speakers who are going to give us a brief talk, and then we'll have a question and answer afterwards. So first of all, join me in welcoming the Right Honourable Suella Braverman, KC MP. Yeah, absolutely.
Let me just deposit my...
Yeah, deposit your stuff.
I come with a lot of equipment. I come with a lot of baggage, really, don't I? Great. Well, thank you very much for making it on this. Are you bleary-eyed? Are you bushy-eyed and bright-eyed and bushy-tailed? I'm not quite sure. There's a few bleary eyes in the audience, but very good to see a packed house at the Prosperity Institute event this morning. And I want to just say thank you to PI, Rado and Guy and your great team for helping me to write this report. We did it as a team effort, and I think it is I'm going to blow our trumpet here. I think it is a landmark report. It's the first time that we have put together not just the arguments about why or whether we should leave and what's good about the ECHR and what's bad about it and agonised about it, but we've actually gone a step further and broken new ground to say it is the only thing to do, but more importantly, this is how we do it. And that's where we've got to shift the debate now. I think we've been poring over the whys and wherefores for years. I myself became pretty convinced of the need to leave the ECHR several years ago, but I think we now need to move the national conversation to how we actually make a success of it, because if we are to deliver it after the next election, we need to be prepared on day one. This will be a critical change and piece of reform that must happen from the beginning of any new administration. And hey, listen, I still live in hope. If Keir Starmer is listening out there, you are welcome to read the paper. Who knows, maybe he will wake up one day and realise that he too needs to leave the ECHR, but I'm not very optimistic about that. I want to also just say thank you to Outpost Films for putting together our amazing video. Who likes the film? Exactly. It will be available at all Blockbusters from... Does Blockbuster still exist? No, it's not. No, it doesn't. You see how old I am. And we need to be showing that in the movie halls around the country, don't we? And I think it was a very powerful film because it really summed up what can be a very dry subject, very legalistic, very weighed down with black letter law and judges and law acts of parliament. And I think what Outpost did was they brought it to life, and we have seen there in 10 minutes the very human impact and, frankly, perversities caused by the ECHR. British veterans, brave British soldiers, now old men, who put their lives on the line to keep the British people safe, are still being hounded through the courts today, 30 years later, because of the ECHR, because of Article 2. When I was Attorney General, under Boris Johnson, we worked very hard to build legislation in the form of the Troubles Legacy Act. It was almost impossible to put that legislation together because of the constraints of the ECHR, which make it almost impossible to bring closure on this lawfare, as we call it. I think that's one of the most powerful reasons as to why we actually need to leave, to stand up for our brave men and women who stand up for our country in the name of our national security. As Attorney General, I was unable to bring an end to some of the chaos, the legal chaos, caused to the law of public order and public protest. We saw there the Colston statue case, a notorious case now. BLM rioters pulled that statue down with impunity. That should have been an open and shut case of criminal damage. This wasn't a question of fact. They used the law, they weaponized human rights, and in court, they pleaded their innocence based on their human rights, invoking Strasbourg jurisprudence, Supreme Court jurisprudence, interpreting Articles 10 and 11, saying that their rights to assembly, their rights to free expression were more important than our rights to live in a safe community. Absolutely perverse. And then as Home Secretary, as you saw, I was unable to deport a single person who arrived illegally on the boats because of being hamstrung by the ECHR. We also saw vividly, all of us, how in the summer of June 2022, the planes were grounded. It was the ECHR, effectively, that thwarted the Rwanda policy. Boris Johnson's government worked very hard to secure a legitimate international agreement with Rwanda. The principle and the idea of the Rwanda scheme was the right one. And as Guy said, many of our European counterparts were very interested in possibly copying it. They were waiting to see if it would work for the United Kingdom. And whether it was when the planes got grounded on the tarmac because of an irregular form of injunction that was issued at the 11th hour by still an unnamed judge in the Strasbourg court, which stopped those planes from ever taking off, wholly undermining the will of a democratically elected government to enter into international relations and, more importantly, control its borders. Or whether it was subsequently when the Rwanda plan was shredded to pieces through our courts because of distorted and perverse interpretations of the European Court on Human Rights, of the European Convention on Human Rights. And so that was the death knell. The ECHR was the death knell. And there's no way we will be able to stop the boats as long as we remain tied to the European Court of Human Rights in Strasbourg. That is clear. And so for all the tough rhetoric from the Home Secretary, for all the messages of reform from this Prime Minister, we're going to review Article 8, we're going to try and change how the ECHR is applied by our courts. None of that matters. None of that will make a single bit of difference as long as we are still bound by the obligations contained in the text, subject to obligations in the Human Rights Act, and subjugated, in effect, by the Strasbourg court. Anything else is window dressing. So the why we should leave, I think, has been compellingly made now for years. And as I said, I reached this view several years ago through my work as Attorney General, following my work as a barrister. Before I was an MP, I was a barrister for a decade, defending for many years the Home Office in immigration cases. And I saw then, day in, day out, how human rights laws are weaponized against the state to prevent the removal of illegal migrants. So moving on to the how then, and the paper sets out in quite a lot of detail how we make this a success. So first of all, we invoke the measures contained in the text itself. It's Article 58 I look forward to what's his name, Tim Bray, whatever his name, the man with the Union Jack hat who stands outside Parliament with a megaphone, anti-Brexit for decades and decades, saying, don't trigger Article 58, or don't leave the ECHR. I'm sure he will start his protests. But we will need to trigger Article 58, and the paper goes into how to do that. Now, traditionally, that should be within the royal prerogative. A government should have executive powers to enter into international agreements and come out of them. However, after the Brexit episode and Miller 1, notably when Gina Miller took Theresa May to court for triggering Article 50, it is now law from the Supreme Court that we need to pass an Act of Parliament to do so. Question, and actually an interesting debate for someone to look into, as to whether that would still be good law under this current composition of the Supreme Court. But anyway, I go on the law as it is today, and I say that we would need an initial Act of Parliament for the government to be authorised to trigger Article 58. That'd be the first thing we need to do. Next thing we need to do then is, once we pass that Act of Parliament and we trigger Article 58, we have a 6-month transition period. That's what the ECHR says. And in that time, there's a lot of work to do. We need to repeal the Human Rights Act. That's the domestic form of the ECHR, which causes a huge amount of problems for our abilities to circumvent the ECHR. So that needs to go. We then, as the paper sets out, need to deal with the Belfast Good Friday Agreement. This has been used as a reason not to leave. I just heard Hilary Benn the other day saying this would jeopardise peace in Northern Ireland, this would undermine security in the United Kingdom. Absolute rubbish. And the paper sets out in a lot of detail how the Belfast Good Friday Agreement is not set in stone. It is not a sacrosanct, untouchable agreement. It is a living agreement. It has been evolved, it has been changed, it has been adapted in many, many fundamental ways over the last 2 decades, which I set out here in very profound, substantive ways, not tweaks, not wording here and there. Big changes have been made to the operations of the Belfast Good Friday Agreement. And in many ways, it's been breached already. Lord David Trimble, one of the architects of the Belfast Good Friday Agreement, has said that it's already been breached fatally and fundamentally by the Windsor Framework and the Northern Ireland Protocol. That runs a coach and horses in many ways through the principle of consent, which rides through and is critical to the operation of the Belfast Good Friday Agreement. And if we believe Lord David Trimble, the late Lord David Trimble, which I do, you know, a nominal breach of the Belfast Good Friday Agreement has not led to a resurrection of the Troubles or an end to peace. It has meant that institutions and governments adapt and continue. So we need to enter into a renegotiation of the Belfast Good Friday Agreement. That will take strategic, diplomatic and political skill. We engage with the parties of Northern Ireland. All the communities of Northern Ireland have to be consulted. They have to be engaged in this process. We have to talk to the Irish government. They are a guarantor of the Belfast Good Friday Agreement. We go in good faith and we start from the premise of wanting to renegotiate through mutual consent. However, we have to be realistic that if Sinn Féin refuse to agree, if the Irish government refuses to agree to our renegotiation attempts, it is within the gift of a sovereign UK Parliament to pass legislation under the doctrine of parliamentary sovereignty to change the terms of the Good Friday Agreement via the Northern Ireland Act. That's what happened with the Northern Ireland Protocol. When the government was negotiating the Northern Ireland Protocol, the Unionists did not agree to that renegotiation. Nonetheless, the UK government proceeded unilaterally to change the terms via changes to the Northern Ireland Act. So it is entirely within our right, and I would say it would be our duty if an agreement is not forthcoming to proceed unilaterally via changes to the statute in Parliament. We have to make changes to the Windsor Framework and the Northern Ireland Protocol. Paper sets all of that out. And then we have to look at how we prepare for a UK after the ECHR. And I think this is the really exciting part. And this is where my paper goes further than anything else that has been put out there by other think tanks or by the shadow cabinet team. We've looked at what Britain looks like after the ECHR. And after some exploration of the issues, we have come down firmly on the side of the common law and statute. I don't believe that we need a British Bill of Rights. There's been some suggestion that we repeal the ECHR, scrap the human rights, and we present our own British document, which looks very similar. Right to life, right against torture, right to family life, none of the things nothing we would disagree with. The problem with that is it is firstly very much at odds with the common law system. The common law system is the foundation of the English legal system and indeed one of the foundations of our constitution. It's judge-made law, case-by-case law, precedent, responsive, evolving to changes. The common law system has allowed our commercial system, our markets, our economy to be so flexible and so dynamic because it is very distinct to the continental codified system. The continental legal system is about writing things down in a code at the top and handing it down prescriptively, top down, not bottom up. So I believe the common law needs to be rejuvenated. We need a renaissance of the common law. What we have now in the ECHR and the HRA is very much at odds with the traditions of our jurisprudence in this country. We need to go back to what the origins and the value and the virtue of the common law. And statute, as I set out, again, very comprehensively at the end of the paper, all of the protections contained in the ECHR, life, against torture, against inhumane and degrading treatment, private life, assembly, expression, all of these human rights are abundantly protected by statute, as I set out in the film, but as I set out at length in the paper. And a combination of judge-made law and our domestic statute is more than enough to provide a very, very rich set of protections for civil liberties. And lastly, a key aspect of the reform, which we don't go into in this paper, but which really does need another paper, is about reform to judicial review. We have activist lawyers. This is the answer to the question, well, other countries are in the ECHR. They don't have a problem. First of all, they do have a problem with controlling their borders. But what is particular about the UK is we have the ECHR. We have the HRA, which puts the ECHR on steroids. We have activist judges. And we have a very expansive ecosystem of judicial review. So any decision which is made by any arm of the state, whether that's the Prime Minister trying to prorogue Parliament to deliver Brexit, or, Manchester City Council trying to issue a planning decision, from the micro to the macro, everything is up for scrutiny and blockage through the courts, and that's judicial review. And judicial review, as Lord Sumption, I really recommend the Reith lectures from 2019 of Lord Sumption, where he talks about the empire of law. His premise is that judicial review and activist courts have expanded so much in the last 30 years that they've actually supplanted democratically elected members of Parliament. They've actually undermined the notion of parliamentary supremacy, such that ministers' hands, the Prime Minister's hands, are tied by judicial review. So we have to curb judicial review. We have to restrict the grounds of review. We have to raise the legal limits, the legal tests that need to be met before a decision is up for quashing by the courts. And we need to get into a tradition and a practice, a new tradition and practice of using our supremacy muscles, if I can put it that way. For too long, Parliament's been disabled. It's been helpless under the auspices of the EU and the European Court of Human Rights. If a judge errs, if we do get an activist judge, after the ECHR's gone, after the HRA's gone, and a judge issues a ridiculous decision that's on the front pages of the Daily Mail and everyone in this room is horrified by, what's the solution? Parliament steps in and corrects it. We should get into a regular pattern of Parliament reviewing wrong decisions by the courts and correcting them. That is the very heart of parliamentary supremacy. If Parliament says it to be so, the judges must defer. And we need to get back to a culture of judicial deference, which should be one of the underpinning themes of the separation of our powers, something we've lost in recent years. And so a combination of the common law, statute, and corrective bills or acts of Parliament from Parliament to correct any errors made by the judiciary provides a very, very rich set of protections for civil liberties going forward. Now, as you can see, I could talk for hours about this subject. I'm very passionate about it. I'm very pleased that we've managed to put this all out in text for everyone to read, pore over, and debate. Please come forward with your debate and your questions, because I think this is the rich territory that we now need to be exploring over the next few years, and I'm grateful to PI for kickstarting the debate. Thanks.
And now, please welcome Lord Frost to the stage for his twit.
Thank you very much, everybody, and good morning. Sometimes in politics, sometimes in government, you live through the collapse of an intellectual and political edifice that seems unchallengeable. We saw that 10 years ago with Brexit and leaving the EU. Suddenly, it became possible to talk about leaving the EU openly. We're living through it, at least I hope we are, on net zero and energy at the moment. Suddenly it becomes possible to talk about the merits of wind power and solar and gas and nuclear and so on. And we are living through it on migration, on the Constitution, and on the issue of the ECHR. And it's very good that there's now a consensus on the right of British politics to leave the ECHR. We have David Wolfson's paper yesterday. We have the paper that we've just been hearing about that Suella wrote. We've had others from Policy Exchange. All the intellectual energy now is behind the case for leaving the ECHR. And I don't need to go into why. Suella has said a lot of that. There's a lot more in these papers. But the truth is, we know we can't control the borders. We can't legislate effectively on migration, citizenship, lots of related issues, unless we grasp this nettle and leave the ECHR. Now, the question is not so much how. The question is, what do we do to get there? And that involves looking not just at the ECHR itself, but at all the other constitutional international treaty type issues that it is linked to. And this is a complex set of problems. The truth is, the UK is still, to a large extent, a non-sovereign country, unfortunately. Of course we did Brexit. Of course we achieved a huge amount of freedom, political debate, ability to set our own affairs, take our own decisions. But unfortunately the job is not done. The whole country is still subordinate to a foreign court through the ECHR, as we've been hearing. A part of the country is still subordinate to another foreign court, Northern Ireland, through the Windsor Framework. And in fact, the Windsor Framework reaches back to the rest of the UK as well and imposes significant political constraints on what governments can do. We've got political and legal commitments through the Belfast Good Friday Agreement. And we've got this dreadful reset that is being inflicted upon us by the current government. In some ways, what they're taking into is even worse than where we are with the ECHR. At least we do have a judge on the Strasbourg court. But what is being proposed for food standards, for energy, and no doubt much, much more, is going back into taking EU decisions without any say at all in how they are set. And I do think there is a serious risk that this national control that we've worked so hard to try and get to is going to be wrecked by 1,000 cuts over the next few years and is going to get much, much more difficult. Now, that's why we've got to look at these issues in the round. We've got to look at all the connections, all the constraints on our sovereignty, because they are all connected, and it isn't enough just to address one of them. It's the Windsor framework that drives the government to the reset with the EU. It's the Windsor framework that requires Britain, whether we're in the ECHR or not, to maintain pre-Brexit human rights protection in Northern Ireland. And then these human rights arrangements are in turn set out in the Belfast Agreement, makes the ECHR the benchmark for them, requires us to enforce them in Northern Ireland. So these are all connected, and I worry that simply tackling one of them is going to take us through a lot of pain and still not fully solve the problems that we need to deal with. Now, the huge merit of the Prosperity Institute paper, Suella's paper, is that really it's the only one to start to engage with these questions, and they are still not resolved politically. The PI paper makes clear, I think, that Northern Ireland can't be different, that it must be a principle that we have the same human rights and constitutional legislation prevailing in the whole country, in Northern Ireland as well as in Great Britain. The paper acknowledges that achieving that is probably going to mean renegotiating in some way the Belfast Agreement. And I note that David Wolfson's paper, reasonably enough because he wasn't asked the question, but nevertheless it sidesteps this and acknowledges that in his view that we will need different Northern Irish arrangements, because he's not asked to tackle the question of whether you need to renegotiate the Belfast Agreement or not. In my view, you do. Similarly, Suella's paper acknowledges the need to deal with the Windsor framework. And again, David Wolfson's paper, again, he wasn't asked the question, but it doesn't deal with it. He says that the Windsor framework is not an issue for leaving the ECHR. Correct. What he doesn't deal with is the problem that the Windsor framework itself requires us to maintain some level of ECHR rights in Northern Ireland. They are all connected. You have to see this in the round. So what do we need to do? We need to be clear about our objectives. We need to remove the reset that's being inflicted on us, and I don't think it's been mentioned yet, actually, or maybe you did at the start, Guy. The paper that I've written the foreword to at the back from Prosperity Institute, which offers an alternative way forward to the reset that's currently underway. We need to remove that. We need to roll it back when we get the chance. We need to redo or we need to remove the Windsor framework, and we need to withdraw from the ECHR and override the bits of the connected UN treaties, the Refugee Convention, most obviously, that also impose constraints. We need to do all those things, and we need to keep that objective in mind. Now, to finish, I don't think it's the right approach for us in whatever formation to come to power in 3 or 4 years' time, bang the table and say, this is what's going to happen, this is now how it's going to be. Of course, we should try and approach this reasonably and fairly. Of course, we should talk to Brussels, to Strasbourg, to the Irish government, and we should try to reach agreed outcomes, because they are the best outcomes and the most likely to stick. But nevertheless, we must be clear about what we are trying to achieve and not accept second-order objectives. So by negotiation, if we can, by the UK Parliament taking the powers and passing the legislation if we must, and it may well come to that. Now, our leader, Kemi, often quotes the Stepping Stones report that was written for Lady Thatcher when she was in opposition, the look through a lot of policy issues. And one quote in that report, I quote quite often, I've quoted it quite a lot in recent years. John Hoskins, who wrote it, says, and I quote, "It's not enough to settle for policies which cannot save us on the grounds that they are the only ones which are politically possible or administratively convenient." End quote. In other words, it's not enough to do what you can. You have to do what is necessary. It's not enough to do what you can. You have to do what we need to do. And what we need to do now is, when we get the chance, remove the reset, remove or redo the Windsor framework, withdraw from the ECHR, override the UN conventions. That is the position that we need to get to, and we can have an argument about the methodology, we can have an argument about the pace. We must not have an argument again about the final objective, because it will leave the country permanently hamstrung, permanently subject to foreign courts, and permanently unable to do what is necessary to make this country great again. Thank you very much.
Now, ladies and gentlemen, we have some time for questions, and I believe there are some people here with microphones who are going to go around. Microphone there, right, fantastic. The gentleman here in the red tie. Sorry, sending all the way from the back to the front.
Thanks very much. I was just going to ask about reaching down into the lower reaches of the blob. So after you've dealt with the treaty level and then the judge level, what else do you need to do down at the tribunal levels and even into officialdom of the Home Office?
Yeah, absolutely essential part of the reform programme, and you can't do the first without the second. There would need the root cause of the problems is the law, and once you change the law in the form that we've set out, there will be many corollary benefits that flow from that, which will be downstream, and judges will have to apply the new law. They will have fewer grounds to block deportation. They will have a narrower remit on human rights. That will be a consequence of what we change as set out in the paper. But there will need to be new legal training. There will be need to, I studied law at university. An essential module of the law degree around the country back then was EU law. I don't think it is anymore an essential module, because there's still overflows of EU law that still apply. I actually, this is a serious question. I'm not sure if still law students have to study EU law, but EU law, they do still need to. Is it still mandatory? Right, okay, well that needs to, we need to stop. We need to stop teaching about EU law. We need to start teaching about a domestic human rights law, or how to use the common law and statutory interpretation. So legal education we need to change. We need to train our judges in a whole new way, and we need to be much more rigorous. I mean, Robert Jenrick has actually alighted upon this point about the quality of our immigration tribunal judges, and we found too many of them to be compromised or worse, politically aligned. That is unacceptable in the area of immigration law. So there needs to be a sweeping out of political judges and a reinstatement of impartial judicial making.
Fantastic. We have the gentleman there with the glass on top of his head. Sorry, I'm going to go with easy identifiers.
Yeah, very much. I'm Jeremy Maddox. I'm chairman of the largest Conservative branch in the country, in Fulham. So I'd just like to ask, at the moment, the Conservative Party has a bit of a credibility gap, as we know, with the electorate. And talking about leaving or negotiating with the European Union and with our international friends on the Northern Ireland Agreement, it seems like it's not going to work. And maybe we should be fast-tracking that and actually planning that they're not going to agree to something, and work out a plan of action for what happens if and when that happens. And my other concern is talking about interference of parliamentarians with the judiciary. Whilst I understand that many of the judges are not making decisions which are in accordance with the law of the country, which is what they're meant to be doing at the moment, I would be concerned that parliamentarians start interfering and start imposing their will on judges. We need to find a methodology whereby the judiciary actually does what it's supposed to do, which is to correctly interpret the law.
Just on the first point, yes, absolutely. We absolutely must prepare on the assumption that we won't get what we want through negotiation and have the legislation ready to go. That doesn't mean that we shouldn't try and negotiate it, but it's a way of forcing ourselves to be clear about our own objectives and showing our negotiating partners what the alternative is. And we do seem to forget sometimes the UK Parliament can legislate for a lot of things, and we should be ready to do that. I do think too many British negotiators over the years have gone into talks, and we still do it, kind of saying, well, let's see what we can get. We don't think it through too carefully. Let's just go in and see what we can get. And that's a recipe for disaster. Obviously, you never get what you want in those circumstances. So yes, we must absolutely be clear, but we must try and approach it in a reasonable way as well.
Fantastic. The gentleman there in the green jacket, I think it is.
Thank you. William Moses, Chairman of Dumfries and Galloway Conservative Association. We'd just like to ask the panel, does your proposal, does it recognise land rights? Because in Scotland, land law is devolved, and we're perpetually infected with socialist ideologies in Scotland amongst the electorate. They got quite far a few years ago, SNP and Labour, and now we've seen the Greens have been in there. They got quite far on a reforming agenda, which would penultimately result in rights to buy off-market, community groups, etc., which goes against a core conservative principle of the right to property. When they went that way the last time, ECHR actually served as the backstop to their agenda, because the rights to property are enshrined in ECHR. So if we're going to replace it with a BCHR, for example, can I ask the panel, is that going to be in there? And is it going to be cognizant of elements of law that are devolved? Thank you.
Well, the Scotland Act makes reference to the ECHR, and that's why the Scotland Act needs to be changed in Parliament. And one of the guiding principles that we set out in the paper must be uniform application of human rights laws across the United Kingdom. I wrote that with Northern Ireland in mind, but it applies equally to Scotland. We cannot have a two-tier human rights regime within the United Kingdom. And that's learning from the lessons of the Brexit negotiation. So we would remove the reference to the ECHR in the Scotland Act. For devolved matters, if the ECHR has previously affected anything, that would change. We must make sure that there is the ECHR no longer has any application anywhere within the United Kingdom.
Could I just add to that? Because I think the situation you discuss illustrates a general problem, which is that so often in politics, fraught political issues, we're finding one side of the argument immediately thinking about what's the ECHR argument, which article of the ECHR can we bring to bear to neutralise this policy, and I think that's what happened in Scotland on this. And I see it quite a lot on other things I'm involved in, particularly the kind of conscience, moral type issues like assisted dying, for example. I get a lot of material that says this is in breach of article whatever it is of the ECHR, and it probably is. But we can't, that in a way is just trying to short circuit politics. We have to assume the responsibility ourselves as a responsible country to have the political and legal debates that surround these questions and get to a reasonable point. We can't always be outsourcing it in the hope that you can win a kind of tactical victory for the outcome you want at the strategic price of losing your right to kind of decide anything fundamental. So we've got to try and break that habit, I think, in the next few years.
We've only got 5 minutes. I'm going to take 2 more questions, more if we can manage. First, the gentleman here with the T-shirt.
Do you think part of the problem we've had so far as, sorry about my throat, is all the shouting over music on a night? Part of the problem that we've had with the electorate is that we've failed to explain to them why we were failing to get people out of our country because of the ECHR. I think the electorate may have been a bit kinder to us, potentially, if we'd had a bit more of an explanation for them.
Totally. Do you want to do the other?
Yeah.
Okay. I mean, I very strongly agree with that. Again, too much of politics has been looking at the polls, seeing what people think, and trying to accommodate ourselves to it. And of course, one must be realistic. One can't just ignore it. But politics is about persuasion. It is about trying to change people's minds about something. And one of the things I remember very strongly about Lady Thatcher when I was a teenager student in the 80s was she was always talking about what she was trying to do. She was always simplifying it down. She was always making the case till it sank in. And we have got to do the same over the next few years. That's why it's so important not to go quiet having made the announcement and sort of allow ourselves to think further. We've got to be arguing the whole time so that when and if we win the election, people are ready, they understand why it's being done, and we can get on with it.
So, do you want to say anything? Or?
No.
Next question. The gentleman there with the blue and yellow striped tie, I think this.
You made a point about that we need to go further and reduce the activist judges. Would you be in favour of doing something along the lines of abolishing Tony Blair's Supreme Court and restoring the law lords? And can you foresee any negative side effects of leaving the ECHR?
I'm in favour of abolishing the Supreme Court. I don't think that it has helped or enriched our judicial decision making. It has undermined our conventions, and I think it was. I think it has led to this activist judges problem that we've seen. So I do support undoing the Blair reforms to our judiciary.
Could I just add it once again on that? Anyone remember the Fixed Term Parliament Act? It was it was a Cameron Lib Dem innovation bolted onto our system. It never worked. The Boris government had the courage to scrap it, and now it's as if it has never been, and we've gone back to normal. And that's what we've got to take the courage to do on a few more of these Blair era reforms. Go back, and we'll find we never needed them really in the first place.
Fantastic.
Equality Act is the other thing.
Yeah,
Gotta go.
Yeah.
Gotta go.
Oh, there you go. Popular, very popular. And over here, the gentleman there at the back is standing up.
Des Cooper, just a member from South Staffordshire. Just like to pick up on something that Guy and David said. Guy, about the right being united in supporting this motion, and David on the steps to power. Could this be a vehicle for uniting the right so that the right does achieve some sort of power at the next election?
Well, actually, when we it's interesting you say that, because when we launched the paper a month ago at the PI offices, Richard Tice from Reform spoke and endorsed the paper. Arlene Foster, who doesn't sit as a DUP peer, I don't think today, but is obviously a former DUP, former minister, has written the foreword to the paper. This paper has commanded cross-party support, and the DUP, members of the DUP are supportive of it. So I think this does show that this is can be a catalyst for, it has already, the right is united on this issue, whichever way you break down the right. So that is to be welcomed.
Fantastic. And I'm afraid it is 10 o'clock. I know there's still lots of hands. That's testament to you for all getting up early and being here, and for it being such an interesting subject, and also testament to the very good work of our panellists here. You've written a fantastic paper and given, I think, a fantastic event. So join me in thanking them.